Good day to all of you, and welcome to another session of Conversations That Matter. I am Tony DiResta, a partner at the law firm of Holland & Knight, and I'm privileged to co-chair the firm's Consumer Protection, Defense, and Compliance team, and I'm joined by my colleague, Ben Genn. Today, the topic is artificial intelligence, AI. It's already being regulated by the Federal Trade Commission, who is very active in overseeing the development and use of AI technology. Indeed, this is a highly relevant topic right now, and it should be of interest to all companies in all industries, as AI technology has been integrated into all aspects of business operations. Indeed, last week, the Biden administration issued an executive order on the safe, secure, trustworthy development and use of AI, and the order actually encouraged the Federal Trade Commission to use its existing authorities to ensure fair competition in the AI marketplace and to ensure that consumers are protected from the harms that can result from the use of AI. And FTC Chair Lina Khan posted on social media, quote, "There is no AI exception from existing laws, and the FTC will continue to promote fair competition, privacy, and honest business practices," close quote. Today, Ben and I have the real privilege to talk with Michael Atleson at the Federal Trade Commission, who will address some topics involving AI, including the regulation of AI by the FTC, the laws and the regulations at issue, law enforcement actions by the Commission, and risk management strategies. Michael is a senior staff attorney in the FTC's Bureau of Consumer Protection. He's had several management and staff positions since joining the agency in 2006. He's engaged in enforcement and policy work, as well as consumer education and business guidance. Currently, in the Division of Advertising Practices, he works particularly on matters relating to artificial intelligence and online reviews. He was the primary drafter of two very important and recent commission reports to Congress, one being Combating Online Harms Through Innovation, the other Social Media Bots and Deceptive Advertising. And he is also the author of the FTC's recent AI and Your Business blog series. He's previously worked for a federal judge and a litigation firm in New York City, as well as for state agencies in New England. He is a graduate of Wesleyan University and the New York University School of Law. Michael, welcome to the program.
Thanks very much.
Let's start at square one, Michael. We'll talk about just trying to level set the conversation. In terms of defining AI, how does the FTC define artificial intelligence?
Let me first say, before I forget, that as any FTC staff person would say, before giving any remarks, anything I say today doesn't necessarily reflect the views of the commission or any individual commissioner, which is something that, as I become older, becomes more and more important for me to say, because, you know, I'm liable to just shoot my mouth off at any time. So I have to cover myself a little bit. So the FTC itself doesn't have like an official definition of that term. We've said, as have many others, that it's a very ambiguous term that means different things to different people. In fact, you put 10 computer scientists in a room and say, don't come out until you've agreed upon a definition of artificial intelligence, we'll never see them again. But there are federal laws, and I think the executive order and other federal sources that do give relatively broad definitions, often involving the use of computation to make predictions or recommendations or decisions. Now, the side note, these days, some people talk about AI generally when they really mean chatbots or other forms of generative AI, which is the hot thing to talk about these days. But it's important to remember that AI includes a lot more, including all kinds of like probabilistic tools, using advanced computation across a wide range of use cases, finance, medicine, science, transportation, education, warfare, law enforcement, housing, you name it. But bringing it back to the FTC, for our purposes, we see it often being used as a marketing term, in that startups have learned if you add AI to your name, you can add a zero or a couple of zeros to your valuation. And I wish I could do that with my name. Holland and Knight might want to do that. Just put Holland and Knight AI, and I think your firm would be worth a lot more.
They are. Our marketing folks love you for saying that. Yeah.
And companies are pitching a huge range of products to other businesses, and they're now directly to consumers using AI as a selling point. So that's why we say it's a marketing term.
Interesting. A follow-up from that, Michael, how does the FTC frame AI issues, and how is it different from how tech companies frame them?
Well, thank you for asking me that question. I know the last answer was a little long. This one's a little long too. Promise everything else is going to be short.
Go for it. No, we're all ears, my friend.
Okay. So we look at things through the lens of our own mission and the laws that we oversee, obviously. So we think that we do a good job of avoiding the trap that tech companies, at least some of them, set for the public by framing their new tools through the lens of the tech itself rather than what they're doing with it. And that's certainly true with AI. When companies do that, they're hoping we think of AI as a complex or even magical or dangerous thing. They can even benefit from admitting, as some of them are now doing, that some kind of new regulatory scheme is needed. Why? It's because that pitch gets people to look away from the laws that already exist and apply at least to some of the things the companies are doing. You quoted the chair before. She said repeatedly, there's no AI exception to the laws on the books. The companies know, and I think we all know, that passing new laws is a long and hard and uncertain process. So if you acknowledge the dangers of AI, it's in their interest, because it may mislead people to conclude that, well, I guess we need to leave it to the companies to protect us because they're the only ones who could possibly understand or control it. And some of the industry have actually said as much. And also, by focusing on the tech rather than what they're doing with it, can also maybe allow them to create some false sense that what tools they're releasing to the public are somehow necessary or inevitable, and skip questions about whether a given tool is it actually has value, whether it actually works, what kind of harmful impacts it would have, or whether it even should have been released at all. And that's not to say, by the way, that there aren't lots of great use cases for all kinds of AI. And, it's a joy to read about them sometimes, but addressing those use cases, not my job. My job is to look at things that violate the laws my agency enforces, whether it comes to AI or otherwise. So for us, the issue basically comes down to four things that we understand very well: companies, data, people, and money. And that formulation I've mostly stolen from an AI ethics attorney named Elizabeth Ramirez. And I can go more into what I mean by that later if you want. But just to end this answer, some AI
Can you say those four pillars again, Michael? I mean, that's very interesting, the way you're slicing and dicing it. I've never heard it stated. Can you say that again one more time, please?
So we think it boils down to companies, people, data, and money. And here's what I mean by this. So it's the realization that the data that is used by many AI systems is often data about us. It's about people. It's about data representing who we are and what we've said or done and what we look like. And it's data that a bunch of low-paid people, usually in third world countries, thousands of them, millions of them, have cleaned and labeled for these big whose employees then use, fancier math than I'll ever understand to turn that data into numbers and then turn those numbers back into some sort of output, maybe text, maybe a prediction, maybe an image, a recommendation for some end user, but often not before more rounds of people working for the company, either as contractors or otherwise, are fine-tuning that system to improve and clean up a lot of the output. And obviously, it's making a lot of money, both for big companies and small startups. And note in terms of people that the end goal of some of these systems, as we've been reading about in the press, may be to reduce the labor costs of the companies that are making or selling and buying these tools, even if it turns out that it doesn't necessarily work as well or do as good of a job as the people that are being displaced. So AI is about, by, for, of people all the way through. It's about the money that companies can make with all that we're giving them or they're taking from us, and it's not alien, it's not working by itself, and that's really how we look at it here.
Interesting, Michael. I know the next questions that necessarily follow are the tools in your toolbox. Ben, I'm going to turn it over to you to talk about the legal underpinnings.
Sure, thank you, Michael. It's a pleasure. Thank you for joining us today. You touched on it briefly at the top of that answer. Speaking of laws, what are the legal or regulatory bases for the FTC's oversight and law enforcement actions concerning artificial intelligence technology and the marketing thereof?
On the consumer protection side, the principal authority is the good old FTC Act, many decades old now, and its flexible and general prohibition on deceptive or unfair practices in commerce. And that covers a lot of things, including many industries and many types of products and services. But that limitation to things that are, quote, in commerce is important, including, especially when it comes to AI, because it means we don't have jurisdiction outside of the commercial arena. And so we can't regulate things that are just sort of political or social.
And dovetailing off of that, does the FTC also consider deceptive omissions of material fact or misrepresentations within the AI context to fall within the purview of Section 5?
Yeah, absolutely. So there's a couple ways that AI tools or systems could be the subject of deception claims under the Act. There's instances in which AI is the selling point, which we call the fake AI problem, and cases in which AI tools are used to deceive, like a deepfake, which we refer to as the AI fake problem.
Can you talk about the fake AI problem and what you mean by that?
Yeah, so that would include like deceptive claims that exaggerate an AI tool's capabilities or claims that it works better than some non-AI alternative. And the second category, by the way, the so-called AI fake problem, that would include things like the use of voice clones and deepfakes for imposter scams, or their use for false advertising, like fake celebrity testimonials, fake online reviews. And it would also include the use of some AI tools like large language models for outright fraud in the form of developing like phishing messages or malware.
Michael, are you able to provide a couple real world examples, specifically in the business context, of whether it be deepfakes, clones, or any of the other fake AI problems you mentioned?
Well, we've actually written a few posts for consumers about the family emergency scam, the one where someone will call a parent and claim to be their child or claim to be a grandchild and ask for, say they're having an emergency and ask for money. That scam has existed for a while, but with voice cloning, it's now become much more hyper realistic. Another example that we've all probably seen in the news recently is the use of AI-enabled deepfakes to suggest that celebrities are hawking a particular product when in fact they're not. And celebrity testimonials are nothing new. We've had plenty of cases involving fake celebrity testimonials, but none of them were created by AI before. And presumably we're going to see a lot more of that in the future.
And Tony, before I turn it back to you, one more question for Michael. Michael, you mentioned celebrity endorsements, testimonials. Can you explain the FTC's work in regulating the social media and advertising context, specifically with brand ambassadors, blogs, online reviews, and the like?
Yeah, all of that stuff falls under the FTC Act and its prohibition against not just deceptive practices generally, but false advertising. We have a long history now, including things on social media, where we've brought cases involving marketers' use of influencers and ads on social media. We also have a lot of business guidance on the topic in the form of our endorsement guides, which we recently updated to include more social media examples. And we have some other guidance as well on the use of reviews, online reviews, either by platforms or marketers.
Great. Michael, let me ask you, right now my mind is trying to merge and swim between the guidance, the social media issues and AI issues. Is fascinating. I mentioned in the introduction the Biden administration's executive order. And how does the FTC intend to work with the administration's goals of managing the risks of AI while ensuring responsible innovation? Have you all developed an internal conversation with the administration? Is there any dialogue going on internally? Is there any kind of staff energies being developed to deal with AI and what the administration is interested in?
So there's certainly a lot of work going on in the commission, both on the competition side and the consumer protection side, relating to AI. And any conversations that anyone at the agency might be having, with the executive branch is sort of above my level. We're an independent agency, and so that's reflected by the fact that the executive order itself doesn't direct the FTC to do anything like it sort of directed NIST and HHS and some other agencies to do things. You mentioned earlier that it encouraged the FTC to use its competition authority, its existing competition authority with respect to AI. And our agency did issue a blog post a few months ago about how we look at competition issues in this age of AI. The executive order, although not mentioning us by name, does talk in another section about using existing legal authorities relating to consumer protection and privacy. So in my view, what the executive order is saying is keep doing what you're already doing.
Got it. Ben, I'll turn it back to you in terms of enforcement actions.
Sure. Thank you, Tony. Michael, you gave a couple examples a few minutes ago about potential deceptive or unfair practices. Can we drill down on those, and can you provide some examples of FTC enforcement actions that involve the AI products?
Yes, and this will include not necessarily just AI, but other kinds of algorithmic systems or automated tools. So I think all in just the last year, we've brought 3 cases involving false or unsubstantiated claims about algorithms or AI being used for investments or business opportunities. That's the Wealth Press case, Automators LLC, and DK Automation. You can find more about all those cases on the website, but they all involve companies making claims that people could make more money via investments or business opportunity thanks to some kind of automated tool or AI or algorithm that work behind the scenes. We've also had some cases involving health claims for products that allegedly used algorithms or some kind of smart technology. One's called Physicians Technology, and that involved, I believe, some kind of device that you would, I think it was made of plastic, but you could like put it on your body and it would supposedly help reduce pain. It might be surprising to you, it didn't actually work. And there's another couple of cases involving apps on your phone where you could like point your phone, I think maybe using the light on the phone, at moles on your body, and it would supposedly tell you whether it was cancerous, and it might also surprise you to learn that that wasn't necessarily true. We also have some cases involving AI that are in the privacy area. We have a few cases, including one called EverAlbum, which involved misrepresentations regarding the use of facial recognition technology applied to your photos. And more recently, we had cases involving both Alexa and Ring, in which we alleged that the company was collecting personal data about users for one purpose, but then without consent or without consumer expectations, were then taking that data and using it to train various algorithms.
In that instance, what should those companies or should those companies have done or not have done?
In the Alexa and Ring cases in particular?
Correct, and the different uses of data, disclosure, consent to the same.
Well, the main thing is to be transparent with users or consumers about what data you're collecting and why and how it's going to be used.
Okay, Tony, back to you. Thank you, Michael.
Oh, Michael, I think I know the answer to the question, but I can't help myself by asking to show the commission's interest in AI. The Washington Post recently identified an FTC civil investigative demand concerning an investigation against OpenAI and ChatGPT. And in reading what the Post had attached as the CID, it was just breathtaking in terms of the issues, the specifications, the breadth and the scope of the inquiry. Are you able to tell us about the status of that investigation?
I have no comment on that. And our law enforcement investigations are generally non-public. And as far as I'm aware, the agency hasn't actually acknowledged whether such an investigation exists.
Okay, I had to try. Okay, thank you. Then I'll hand it back to you, sir.
Thank you. Michael, we haven't yet touched on this, but we think it's an important issue given some of the commission's investigations and enforcement actions brought within the bias and discrimination realm. It's obviously a concern of many federal agencies, but what are the ways in which AI can contribute to unlawful bias and discrimination?
So there is a lot of great scholarship and reporting on this topic and many examples, like globally, of situations in which algorithms or AI systems have discriminated, often inadvertently, against women and minorities and people in marginalized groups, non-English speakers, etc. And in some of those cases, some kind of law, international law, federal law, state law, is going to be at issue. And some of these examples even involve the work of government agencies. And they run from the gamut, housing to social services to hiring decisions to criminal law. And there's a number of reasons why systems might behave this way. The most obvious one is, bias that is embedded in the data on which the algorithm was trained, or how the model uses proxies in the data, or whether the model is being used for something other than its original purpose. We could potentially use an unfairness theory under the FTC Act for AI systems that cause biased or discriminatory results, the way we did recently in two cases that didn't involve AI, but could have. And there are two cases involving auto dealers. One's called Rhinelander, and one is called Passport Auto, in which we alleged in the complaint that those companies engaged in unfair conduct through the disparate treatment of certain types of people when it came to things like add-ons to the car sales or loan terms. So recently, Chair Khan issued a statement along with a few other agencies, DOJ, CFPB, and EEOC, about algorithmic discrimination, saying each agency is going to use its own authority to combat the problem. But it's not the first time we've talked about it. I have a colleague, Elisa Gilson, who wrote a blog post on this topic a couple of years ago, which was fairly influential. So it's not a concern, not a new concern for us at all.
And Michael, you just touched on other agencies.
I'm sorry, I'm interrupting you a second. Michael, you mentioned the joint statement with the DOJ, CFPB. Is the commission working with other agencies, coordinating efforts to deal with AI issues?
I think what I know about are some informal communications with other agencies, the way that we would do on just about any other issue when it makes sense. The one other example that I can think of that would be public is that along with the CFPB, we've been collecting information pursuant to a public request about tenant screening tools and whether they can be biased. So that's an example of joint agency work right there.
Ben, back to you. Sorry, I didn't mean to interrupt. Sorry.
No, you took the question right out of my mouth. I was going to ask whether, while each agency believes they have the authority in the AI realm, whether there was in fact coordination, referrals, etc., between say DOJ and FTC, and it sounds like yes, at least informally to date.
Yeah.
Michael, is there any coordination with the states, say through the state attorneys general, or is it pretty much a coordination just on the federal level?
Well, I don't know about AI matters, but as a general matter, in the Bureau of Consumer Protection, we are coordinating and talking to people in the state AG's offices all the time. And you'll also see them as co-plaintiffs on a number of cases, which has become more important since the Supreme Court's AMG case made it so much more difficult for us to get money back to injured consumers. If a state AG can do so, then we like to have at least one of them along for the ride with us so that we can get that kind of relief.
Got it. Got it. Ben, sorry, I interrupted you once again, my friend.
That's totally fine. Tony, if I may, and Michael, a question about transparency and its relevancy to any FTC analysis regarding enforcement actions and AI. There's been a lot made of transparency, and one theory in academic circles relates more to transparency in the source code. But has the FTC found an avenue yet that could become or is viable with respect to this?
It is a topic that's talked about a lot, and it's a very broad concept. And it's hard to talk about it without thinking about, okay, well, transparency by whom, of what, to whom. We don't have authority to, require AI companies to issue public transparency reports. But as an enforcement and regulatory agency, we can get information from companies in various ways. So, for example, we can do a market study, and we're doing a couple of them right now with social media and streaming companies about their privacy and advertising practices. We can get the kind of information that you might want from such companies through an investigation or in the course of litigation. And then in a court order, we can require companies to do internal or third-party assessments, which is something that we've done regularly in security and privacy cases. And in some advertising cases also, of course, we'll require companies sometimes to make certain kinds of public disclosures, nothing like a transparency report. And of course, under the FTC Act generally, it can be deceptive for companies to do things without being transparent with consumers. But again, that's different from requiring companies to unload a lot of information, whether it's in the form of source code that is only going to be valuable to certain kinds of researchers and others, and transparency about other aspects of how companies are using AI systems. So that's largely going to be a topic for legislation, which is something that we talked about in one of the reports, the Combating Online Harms report that you mentioned at the beginning, Tony.
Michael, let me ask you about this. It just comes to mind about the duty to monitor conducting due diligence. Does the commission believe that there's a duty to monitor AI products? Meaning, what are the legal duties of a company that subsequently hires a third-party vendor to provide AI technology or services? What is the responsibilities, the liability lines in that scenario?
So whether we're talking about AI or something else, under the FTC Act, all companies can be liable for what vendors or contractors do on their behalf. There's no vendor defense under the FTC Act. So,
Okay.
Vetting these third parties and monitoring what they do and how they do it is very important, whether you're talking about AI or something else, because that can be very relevant in terms of our enforcement discretion and what cases we're going to bring or what relief we're going to seek. And as far as I know, there's no specific statutory duty, whether for the FTC or anybody else to enforce requiring monitoring of AI products and services, which is not really different from products and services in most other realms. But if your product causes or is likely to cause substantial harm, then you might be engaged in unfair conduct under the FTC Act. And one of the things we'd be looking at is, were you monitoring the use of that product? So that risk is going to be on you. So in other words, you might be able to get away without doing any monitoring of whatever the product is, if no harm results. But if harm does result, the fact that you haven't done any of that stuff is going to be bad.
Got it. Thank you. Got it. And Michael, off of that, touching on disclaimers, can disclaimers be used in the context of marketing AI?
They can, but the extent to which disclaimers or disclosures are going to be useful here, or the extent to which they can limit one's liability is, again, no different with AI claims than with other claims. And it'll depend on a lot of factors. I mean, sometimes a disclaimer is just not going to cut it. It has to be clear and conspicuous, first of all, meaning people actually have to be able to see it and understand it. And there are going to be some cases where no disclaimer is going to change the deceptive net impression of your marketing content. Put another way, like you can't draft a disclosure that cures a flat out lie. or something that's like facially or blatantly deceptive. And it might also be meaningless, a disclaimer would, in an unfairness case, because that kind of action involves harm to consumers that they can't avoid and likely would never see in the first place.
So it's the clear and conspicuous standard, that similarly applies to social media and marketing and advertising that would also apply here to any AI claims.
Right. At least for deception cases. For unfairness cases, again, it might not matter what disclosure you have if no one's going to see it or if they can't do anything about it.
Okay, thank you.
Michael, I'd like to ask you about topic that comes up in the, I know in some of the literature, and it's algorithmic deletion and the kind of remedies the FTC would use in enforcement actions. I guess broadly speaking, is algorithmic deletion a remedy that the FTC would consider? I note that the former FTC Commissioner Chopra, current Director Chopra at the CFPB, stated that no longer allowing data protection law violators to retain algorithms and technologies that derive much of their value from ill-gotten gains is an important course correction. So thinking through, what he was saying and the wisdom potentially contained in that, what types of remedies will the FTC consider in AI enforcement actions?
So to take that last question first, we consider all the same types of remedies that we get in other consumer protection cases. That would include injunctive relief with provisions setting forth what companies can or can't do in the future, or what proof they need before making some certain kinds of claims, and when appropriate and legally available, monetary relief. So as for algorithmic deletion, which refers to the idea that if you've collected personal data you shouldn't have, or collected it for one purpose and then used it for another, we might want to require the company to delete not only all that data, but also any algorithms that have been developed from it. And we would not only consider it, we did consider it, and we've gotten, I think we're up to 6 cases now. I'd only known about 5, and I just looked the other day and thought, oh, there's another one, that actually have algorithmic deletion provisions in them. That's Everalbum, the facial recognition case I mentioned before. There's one called Kurbo, K-U-R-B-O, which is also known as the Weight Watchers case. There's one involving everyone's favorite company, Cambridge Analytica, and the Alexa and Ring cases that I mentioned before. And finally, the one that I didn't know about, Edmodo, which I think is an EdTech case, although I don't remember for sure. So that's at least 6 cases with algorithmic deletion provisions covering a bunch of different types of products.
Thank you. Thank you.
Thanks, Michael. And I think a lot of people here listening want to know some concrete takeaways. So can you discuss the best practices for companies or businesses to employ when creating or using AI technology or similar products?
Yes. So recently we came out with an enforcement policy statement on biometrics. And yes, I realize biometrics is not AI. But there are some recommendations in there which are like easily adjustable to the AI context. And drawing from that statement, there are some sort of high-level things that we think are important. One is doing pre-product release assessments on foreseeable harms. Another is taking steps to mitigate the risk of those harms, and not releasing the product if you can't adequately mitigate those risks. A third is being transparent about the collection and use of personal data, which I mentioned before. Another, and the other 2 are actually things we also talked about, the vetting vendors and also training your staff, and ongoing monitoring. That would be the 5th one. And there are many public and private sector resources to help firms, big, medium, or small, with these tasks. The first one I'd mention would be NIST's AI Risk Management Framework, There's also
Mm-hmm.
a lesser known federal source, and that's the Partnership of Employment and Accessible Technology, or PEAT, which is a federally funded group which has resources about training.
Thank you. And then touching on that, Michael, and discussing pre-release, risk management, what sort of safeguards can a company implement to limit its liability? I know you touched on it earlier in the disclaimer section, but how relevant is the standard of reasonable foreseeability and the reasonable data security standard here?
I think reasonable safeguards are going to, of course, depend on the particular product or service at issue. But let's just take one example: a tool that creates deep fake imagery. It's been in the news a lot recently, right? An obvious
Mm-hmm.
question for such tools is, for the company that's developed the tool and put it out in the public, what have you done to mitigate the obvious risk that such a tool is going to be used downstream for fraud or for the creation of non-consensual imagery, which, after all, has been the main use case for deepfake tools going back to when they were first created years ago? What frictions have they built in, or filters, to prevent the tool from responding to certain kinds of prompts? We heard about that in the chatbot situation as well. And how durable or robust are those kind of guardrails? Can they be easily removed by third parties who are using that tool downstream? And coming back to monitoring again, like what steps have you taken, technologically or otherwise, to monitor the downstream use of those tools once you've released it, and what are you prepared to do if you see it being misused? So you mentioned like reasonable foreseeability, and that term is in the FTC Act, which does not have an intent standard for Section 5 violations. For us to bring a case involving unfair, deceptive conduct, we don't have to prove that someone knew that they were going to have, that their product or service was going to have that result. But in an unfairness case, the reasonableness of a company's conduct and what they knew and when may well come into play. And that will include the questions of, what did it know or should have known about how its product was going to be used and what the impact was going to be. You mentioned data security, and I think that's a really good analogy because, over the years, we've brought these data security cases and developed effectively a common law set of standards about what amounts to reasonable data security, not just through the cases, but also through a lot of business guidance. And some of those standards might be quite relevant, especially in an AI-related case that involves the collection and use of personal information, but that's more of a question for my colleagues in the Division of Privacy and Identity Protection.
Thank you.
Want to just step back and take a breather here. For those of you who are getting or seeking CLE credit, there is a code that I need to give you, and I sure don't want to forget. The code is HK2311077445. Again, the CLE code is HK2311077445. Michael, let me ask you this. I know we've been talking FTC, we've been talking about the Biden administration nationally, America, United States. What about EU regulations and guidance? Does the FTC ever look to the EU for guidance based on its relatively advanced data protection type legislation?
Well, since I'm not a privacy lawyer, or haven't been one for, I think, 15 years or so, I can't really talk about, comparisons between the US and EU on the privacy front. But in terms of AI, we are certainly interested in what's been happening and what will happen in terms of implementation and enforcement with the EU's AI Act and also with AI regulation in other countries and in individual states, which are all, experimenting in this area. And so we're aware of what's happening, and I think every legislature and relevant regulator should be looking at these things to see like what's worth borrowing and not worth borrowing, even if it involves countries or that are places where we otherwise wouldn't want to emulate.
Thank you. Got it.
Uh,
Then I'll shoot it. Friend.
Sure, Michael, not a gotcha question, but
Yeah.
maybe close. Is it fair to say that the FTC and other regulators have publicly stated that the agency has all necessary authorizations under existing laws to regulate or bring enforcement actions for inappropriate use of AI systems case?
Well, I can only speak for the FTC, and I'd say not quite a fair statement, no. So what Chair Khan and other agency officials have said clearly is that we do have authority to take actions relating to AI under existing laws, but it's not like they said that we have all the authority that one agency or all agencies need for the broad goals of ensuring that all AI systems are used appropriately. We've got our authority involving deceptive or unfair conduct or unfair competition. Other agencies have theirs, and it's up to Congress to determine whether and when they're going to pass laws that give us additional authority or resources relating to AI. I don't think that the chair has come out in favor of any particular bills on AI. It's not something that most FTC chairs or commissioners usually do, but I do know that some FTC officials have spoken in favor of a federal privacy law, and a lot of people believe that a federal privacy law would probably have an impact on the use of AI as well, since AI is often used to collect information and to use it in various ways.
And thank you. That was my follow-up question. What would the FTC like to see come out of Congress if there were additional laws or authorization?
So it's not a question that I can answer without getting in front of agency leaders. The only thing I'd say is that if they ever do give us more authority, we hope it'll be paired with additional resources, because often what happens is when we do get a direction from Congress, whether it's to write a report or work in a new area or whatever, they don't give us any more money or people to do it, which means a lot more triage. It means, okay, we'll do that, but now we can't do something else. And we don't have so much money. We're a tiny agency by federal government standards, or in comparison to some of our sister agencies abroad, we're also very small. And we don't have the luxury like some of the bigger agencies do of not just having more people, but having large contractors that you can just assign those tasks to. So if we get more authority, we'd like more resources to be able to handle them as well as we can.
I'd make a quip that, AI could maybe do it in place of those resources.
Yeah, which might defeat the purpose of whatever we're being asked to do, but might be a shortcut.
Tony, back to you.
Okay, given the time, I'd like to be able to ask you some questions from the attendees, Michael. And I've got a couple of here, and Ben, I don't know if you've received any yet, but one question is this: what kind of guidance can we get from the FTC or developments? Obviously they could look at the FTC website, but is there particular guidance documents, things that companies ought to be paying attention to that are commission authored or commission generated?
Well, I mentioned the biometric policy statement, which again is not about AI, but does give high-level guidance that would apply to AI. The other
Mm.
thing that I would suggest is to sign up to get our business blog posts and consumer posts, and also blog posts from our relatively new Office of Technology, as things relating to AI and lots of other topics of interest are found in those blog posts, which come out fairly regularly. I have a set of 5 AI blog posts that are referred to collectively as AI in your business, which set out a lot of the general standards and considerations that we've been talking about this afternoon. And like I mentioned, there's a competition post as well, and a number of alerts for consumers about different types of AI scams.
Thank you. Ben, do you have any questions from your folks?
Sure. We have 2, Michael. The first is what extra diligence, such as the level and type of diligence, should companies do on AI tools involving consumer personal information beyond the more standard vendor and privacy assessments? We're talking mostly in the unfairness prong here of Section 5.
I don't think the standard is any different. I think the rub with AI tools is that so many people don't understand how they work, and yet there's this super strong push to use them for everything, which is coming a lot from marketing and from a fear of missing out. So while the standard might be the same, the tools themselves can sometimes be, as is often said, black boxes. They don't have to be. That's just the way they've been designed by the companies that are selling them. And if they are, if you don't understand how the tool that you've just bought off the shelf is going to work, and if it's at least possible that could have some unintended harmful consequences, you shouldn't use it unless you've got trained staff, vendors that you've vetted, and ways to determine as best you can in advance and after you start using it, what's actually going on.
And one other question, Michael, does the FTC overlap on Secure Software Development Framework, SSDF, with NIST SP 800-218 regarding the creation of the governing software in AI companies?
I can't tell you that I'm familiar with those numbers, but I think in the privacy and security area, and specifically in cases that have involved insecure software, we have some folks who have looked at what the appropriate standards were, and it may have even shown up explicitly in an order or two in order to sort of guide the company and independent assessors in terms of what they're supposed to look for when they do their assessments. At a higher level, we certainly do talk to folks at NIST and want to support all their efforts in this area.
And the NIST standard relates to mitigating risk and vulnerabilities with the assessment. So it does sound like there is some overlap with the FTC.
Yeah.
Excellent. That appears to be all the questions we've brought in so far. So Tony, I'll turn it back to you.
For Michael, looking at the time, I can't believe our time is almost over, but I want to, in the final minutes, give you the floor, open the floor to you. Are there any closing comments that you might have regarding any additional thoughts, any additional areas of interest that you might think our attendees should hear about?
I think the only other thing I'd add, and it's really a message to companies that are deploying and selling AI products, that a lot of them seem to think that they can freely use consumers as experimental test subjects. This is especially in the generative AI area. Even though their products are associated with known or at least reasonably foreseeable dangers. But we don't think it's appropriate that they are putting the public and regulators into the position of bearing the cleanup burden when those products that they're so desperate to release wind up not working or causing substantial harm. And we're looking very hard at companies that are doing that.
Got it. No, thank you. That's an important message to convey. Michael, Ben, and I, and all of those on this webinar today cannot thank you enough. This has really been outstanding. Your wisdom, your knowledge, your expertise. I definitely have a few more wrinkles in my brain this afternoon, and undoubtedly we'll be reaching out to you again to do a follow-up. This has been terrific. So thank you. Please give our best to your colleagues, and we really appreciate the time that you've given us today.
No problem. Thanks, Tony. Happy to do it again someday.
Terrific. Thank you all for joining. And if there's any follow-up questions, please feel free to reach out to Ben and me. We'll see what we can do to provide any good answers from you. And we all wish you a successful day, a happy fall, and be well. Continued success. So long.